Okay, Senate Minerals is ready to convene. Everybody knows the rules. You wouldn't step out of line at all, and I see there's 2 policemen out there waiting for you to step out of line, so be careful, be careful. First bill to come before us today is Senate File 65, Data Privacy Government Entities. And I see everybody's in complete agreement with it. Yeah, definitely the case. Okay, can you tell us about it?
Yes, Mr. Chairman. Mr. Chairman, this is from the Blockchain Select Committee. So we worked on this during the interim, and we had, extensive engagement, public comment, and spent a lot of time working on this legislation. At the same time, it is a little bit challenging and controversial. We'll probably hear some more concerns. The challenge is raised from the fact that privacy is actually ridiculously inconvenient. The government doesn't really like privacy. It doesn't operate well with privacy. And really, it's better for the government to know everything you're doing all the time to get the job done of government. The intent of this bill, though, is to say, you know what, we'd kind of like to draw some lines and give some rights to the citizens of the state, people of the state, and create some bright lines and obligations for the government to limit the amount of data they collect, to make sure they're not selling that data or even purchasing additional data about you or transferring it to third parties. So basically, if the government has data about citizens of the state, they're responsible with it. And then also to make sure that citizens have the right to understand what data is available about them and to correct that data if there's a problem. So we spent a good bit of time working on this. There are some proposed amendments. I have one also because I've heard some valid concerns since we passed this legislation that I think we need to address, but I'll walk through the bill now, if that sounds like a good approach to you, Mr. Chairman.
Yes, that sounds like good.
All right. So starting on page 2, we've got definitions, and some of these are important definitions that we worked on. De-identified data is an important consideration because de-identified data is going to be effectively exempted from this act. And that means data that cannot reasonably be used to infer information about a natural person effectively or their digital identity. Government entity means the state and all its political subdivisions, instrumentalities, institutions, etc. But this is important, shall not include the judicial branch of government or any law enforcement agency in Wyoming. So we've basically exempted the judicial branch and law enforcement, which we'll define on the next page, because they already have pretty substantial data handling responsibilities and obligations. Mr. Chairman, what's your own?
Excuse me.
Yep.
Mr. Rothfuss, we didn't do roll call.
We could do roll call.
Let's do roll call
I'll push pause.
before he goes on.
Senator Cooper.
Here.
Senator Jones.
Here.
Senator Nethercott.
Excused.
Senator Rothfuss.
Here.
Chairman Anderson.
Here.
Mr.
So we
Chairman,
have a quorum, so we can go ahead now.
And I'm just happy to start over if you'd
Yeah,
like.
no, don't start
No,
over.
I knew you'd say
No,
So let's look at Romanet 3 on page 2. Identified or identifiable natural person means a natural person who can be readily identified directly or indirectly by reference to an identifier such as a name. So that is clearly getting at a specific person, a natural person. Romanet 4 is a definition of law enforcement agency that is basically consistent with other parts of statute, but we called it out here because none of them included all of what you would contemplate as a law enforcement agency. So surprisingly, we had to kind of create our own, and it shall not include the office of any city, county, or district attorney or other division of the attorney general that isn't directly providing law enforcement services. Personal data means information that is linked or reasonably linkable to an identified or identifiable natural person or personal digital identity and does not include de-identified data. So this is really any information about you, and it's very broad with regard to what the bill covers. And then personal digital identity is referenced a few times. That's a reference back to statute just for continuity. All right, on to what the bill does on page 4, based on those definitions. So this is a limiting system that limits personal data by government entities and the use for it. And you see in paragraph A, this is the heart of the bill, no government entity shall purchase, sell, trade, or transfer personal data without the express written consent of the natural person, except as otherwise expressly provided by law, and then with the following exceptions. So each of these concepts, purchase, that was actually what started this bill. There was a purchase of a private data set by a government entity in Wyoming that caused a lot of consternation. So effectively, state funds were paid to find a bunch of information out about people in Wyoming so that a government agency could contact more easily that entity. Well, what happens when the government buys that data set is now it is actually a public record, potentially, or even if it's a confidential record, it still falls into our state records aspect. So once you collect that data, it's not that easy to get rid of. And that turned out to be kind of the source or impetus for let's get this bill going. But as we look at what other states have looked at and kind of what the conversation is, the idea of selling data, we have agencies that sell data, and then other states have agencies that sell a lot of data. Other states' departments of motor vehicles sell their driver's license data to generate revenue. Our state does not do that, but other states do that. Not with permission. It's just, hey, here's a great data set. I could sell this for a lot of money, and so they do. But we do have agencies in the state of Wyoming that sell data. For example, Game and Fish will sell information. You can opt out, but I don't believe you have to opt in unless they've changed things since we had the conversation. So they collect data about hunters and fishermen around the state, and then they sell that data to help generate revenue for it, and that's a common practice. This would, again, allow you to do that, but it would just flip it. So now you have to give express written consent as opposed to opting out. Again, it's allowable, but somebody has to say, okay, this is a good idea before it can be done. And then trading or transferring, that's just trying to get to the consideration of trying to bypass the sell or buy. And honestly, the transfer aspect has caused the most problem, and we'll have an amendment related to that. Express written consent allows that natural person to make it clear that they would authorize the purchase, sell, trade, et cetera. And that's a standard we've used in other legislation on blockchain to make sure that the individual is knowing that the transaction is taking place. So exceptions here, a government entity may transfer personal data to another government entity. In other words, if you're within the government, it's going to be okay as long as you have compliance with the rest of the provisions. On Romanet 2, this is kind of a catch-all exception. We wanted to make sure that unforeseen consequences didn't lead to undesirable outcomes. So a government entity can petition to whatever their elected governing body is or person and say, hey, we can't comply with this statute. We would like an exemption. And that body can actually then vote or make an agreement to say, okay, that's going to be okay. I authorize it. That's a public bit of information, though, so that has to be a little public record so that the people know that their records are being purchased, sold, transferred, whatever the case is, but they'll at least be informed and it'll be on record. And they have to affirm that every 2 years. So that's not a permanent thing. They've got to come back and revisit it. And the idea there by the select committee was, well, hopefully that will apply some pressure to maybe not do whatever that is. If there's a way to work around it without turning out the information, it'll continue to apply public pressure where private information is being disclosed and lead to the public understanding.
Every 2 years in writing?
Every 2 years, they have to provide a written letter, effectively. So they would have to provide authorization. Not just a nod and a smile. The written concept is, here's a little letter indicating the justification for it. That could be the same letter every 2 years, but again, the public might get a little annoyed, and that's the intent. If it doesn't make sense to the public that information is disclosed, they would put pressure on the politically elected individual, and things would change. If the public doesn't care, it'll all work out. It's just probably at that point hitting print and send. On to Romanet 3. And it looks like we've got an amendment that sort of addresses this, but I'm curious to see what the amendment gets at, because Romanet 3 already looks to some federal law concerns, and it indicates that nothing in this subsection shall be construed to prohibit the transfer of personal data that is otherwise compliant with the HIPAA, Health Insurance Portability and Accountability Act, or the Family Education Rights and Privacy Act. And honestly, nobody on the select committee really likes this exception provision. This is a pretty big open door loophole, but we didn't see a way around it. So that provision is there to ensure that those that have to comply with HIPAA and FERPA are already deemed as complying with this statute based on those obligations to the extent that they are required to. The B provision on page 5 indicates that any Wyoming resident may obtain a copy of their personal data from any government entity managing it. And this is kind of consistent with the Wyoming Public Records Act, that they may charge a de minimis or appropriate fee pursuant to the Wyoming Public Records Act. The C paragraph indicates that if the Wyoming resident objects to the accuracy of any of that information, they may request that it be corrected, and the government has to respond within 60 days. And within 60 days, you'll see on page 6, they will investigate the validity of the objection. If it's found to be meritorious, they'll alter the contents appropriately. If it's not meritorious, they'll inform the resident accordingly. And then Romanet 4 indicates that that decision shall be issued in writing. And electronic includes writing, right? When we say writing in statute, we do mean that electronic interactions are allowable. We use the Uniform Electronic Transaction Act and some other provisions that provide for that. And then bottom of page 6, the D provision, to the extent that a provision of this article conflicts with another provision of state or federal law, the other provision shall control. Mr. Chairman, what that means is if this conflicts with some other obligation under state or federal statute where you have an explicit conflict that you can't abide by this law, it's basically an okay, well, if you can't abide by this law, then you don't have to abide by the law. The other statute governs, just to make sure that we're not causing undue problems. On page 7, personal data collection and retention by government entities. This gets at the other side of it, which is the government having to justify what it collects and for how long it keeps it to the best of its ability. We know that our government entities collect a lot of information, and they over-collect, and they hold on to things longer than they need them, and they don't have any obligation to really get rid of them very much, except for some archival policies associated with state archives. So this gets at those terms. So we see actually a reference to the state archives right in the beginning. In the A provision, it says, in addition to the policies required under Wyoming Statute 921-101, if applicable. All right, that's state archive statutes, and they have archival requirements and timelines that are already in statute that agencies have to adhere to for certain records. And this basically says, do that law also, right? You have to follow the state archives laws. And we work with state archives to ensure that they were comfortable with this language. But then in addition to that, each government entity that collects or retains personal data, which is basically all of them, shall adopt, enforce, and maintain a policy regarding the collection, access, retention, security, and use of personal data consistent with all applicable federal and state laws. So it doesn't, and we won't have a lot of detail of what that policy has to look like, but it basically says, if you're collecting data on the public, you have to have a policy about what you're doing with that data, why you collect it, and for how long you're going to keep it. That doesn't sound too challenging, but you're going to hear a lot of public testimony complaining about it. On to the B paragraph. No government entity shall collect or maintain more personal data than is reasonably necessary for the performance of the government entity's lawful functions. In other words, if you don't need the data about somebody, don't collect the data. Again, that seems rational, but it's challenging. And all personal data collected and maintained by government entities shall be necessary for a specific predefined purpose. This goes into the policy. You have to have a reason to collect the data. If you don't have a reason, don't collect the data. On the C provision, no government entity shall maintain personal data for longer than 3 years without an express written policy identifying the extended retention period and providing a reasonable justification for the extended retention period. So what that means, first of all, it does harken back to the archives, where state archives provides requirements of 5 and 10 years and even perpetuity for certain documents. So state archives is going to be a justifiable reason. If state archives says, for example, your birth certificate has to be kept forever, something along those lines, then it's kept forever. So you've got a policy justification, no problem. But if you're collecting data and holding on to that data, you have to be able to point to a reason why you're holding it for more than 3 years, and how long that's going to be and what it's for. There's no restrictions that says you can't write whatever policy you want. So there's no cap on it. If you feel like you need 10 years for a piece of data, you just write down 10 years and you write your justification. But you actually have to have some sort of justification that then the public could see, all right, they're keeping this data for 10 years, here's why. And that doesn't exist right now, right? There's no oversight on the amount of time that data is kept on citizens of the state of Wyoming. This simply says, we're going to have that and you're going to justify it. And if you can't come up with a justification, then you should delete it by 3 years. And then statutory retention requirements provided for in Wyoming statutes 92405 through 92413 constitute a reasonable justification, getting back to the fact that we already have these archival requirements. So in section 3, we see not later than January 1st, 2026, the state chief information officer, in consultation with state archivists, shall develop sample policies for use by state agencies, counties, cities, towns, et cetera. So, this is quite a while away, about a year from now-ish, that sample policies will be developed. And then you see in the implementation date that we have before the effective dates on section 4, 92203, as created by section 2 of this act, shall be effective as to counties, cities, or towns on July 1st, 2027, and as to each political subdivision of the state other than state agencies, counties, cities, or towns on July 1st, 2028. All state agencies, counties, cities, towns, and other political subdivisions shall adopt any necessary policies and procedures to meet the requirements. So we've got kind of a staggered timeline. This would go into effect for the larger portions of the state by 2027, and sort of those smaller entities would go into effect in 2028, so that there's plenty of time to get this done. And then on page 9, you've got some split effective dates to reflect that. So, Mr. Chairman, a lot of the concerns that have been discussed come down to the fact that it's challenging to do this. These are hard things to do. And we heard that, and we understand that this is a hard thing to do. But that's always the problem with privacy, is it's wildly inconvenient. And if we just keep our records forever, life is a lot easier if you're the government. This responsibility seems like it's in the interest of the public, though, and we need to move towards this, even if there are challenges. So we might hear some challenges today. We heard a lot of desire during the interim for exceptions, more exceptions. In general, we were unwilling to provide additional exceptions. The one exception, though, and I've got an amendment to this effect that I'll just raise because I think it's relevant ahead of public comment. The one that came up frequently was the idea, based on the language of transfer data, right? We say that you can't transfer data. And the idea that government entities use third-party service providers where they contract with that third-party service provider, and they're effectively transferring the data to that third-party service provider for the purpose of their business, right? Whatever the government is trying to accomplish using a third-party service provider. So this amendment that you see here, that you've got, the copy that I provided this in LSO draft, provides a little additional language that says, and it inserts a new Romanette on page 4 after line 12. This is the exception language. It creates a new little Romanette 2 that says, a government entity may transfer personal data to a non-governmental entity contracted by the government entity to provide or assist with government services provided by the government entity. Any contract for services with a non-government entity shall include requirements for the protection of personal data consistent with this article. Any personal data transferred pursuant to this paragraph shall be returned or destroyed by the non-governmental entity once the personal data is no longer necessary for the provision of the government services. No government entity shall maintain, sell, transfer, process, or otherwise use the personal data in any manner except as provided or as necessary to provide the contracted services. So this was a common theme that we heard, a concern where obviously our government outsources a lot of their operations, and this makes it very clear that that's acceptable as long as you're working within the confines of the spirit of the bill. So that's the presentation, Mr. Chairman. Happy to answer any questions.
I have a question. There's, on page 7, there's, no government entity shall collect or maintain more personal data than is reasonably necessary. Do they have to go through a court or a judge to determine what they can get? Or is that just within the agency?
Mr. Chairman, there really aren't any like teeth or penalties in this. It's an expectation that our government agencies will follow this law because government agencies typically follow laws. So that is, as you see in the A paragraph, they have to adopt a policy. And they get to write the policy, and it can say pretty much whatever they want the policy to say. The B paragraph is modifying that and indicates, that they shall not collect or maintain any personal data that is unless it's reasonably necessary. And that's going to be based on their determination, but people could push back on it and say, well, this doesn't seem reasonably necessary. And so there'd be a conversation, and, in the case of agencies, maybe the government or the governor gets involved. In the case of counties, maybe they go to their county commission. So you have entities that are always capable of overseeing it and saying, well, why is this necessary? And that's exactly what we intend, right? Nobody's a felon as a result of this bill. Nobody's going to jail. It's very much we need policies that set our expectations of government data privacy, and they need to be fairly rigorous, and they need to be well thought out, and they need to be justified. And so this makes sure that all of our levels of government have that obligation after a couple of years. But again, it's not going to be perfect. No one's going to come up with a perfect policy, but what we have right now is a general absence of policies with the exception of our archival requirements.
So once they determine they need and can collect and personal data, does then the person, the natural person, have to okay it?
Mr. Chairman, no. These entities could collect data as they see fit effectively. The okaying of things comes back to the purchase, sell, trade, or transfer has to be by written consent, but not the data collection. The data collection is pursuant to if an agency feels it needs a record, it ends up taking in that information, just consistent with how it is now. So there's no new requirement to go out and get permissions.
Other questions for the presenter? Other questions? Other questions? Hearing none, let's hear from agencies first. Any agencies like to weigh in on Senate File 65? And everybody jumps up.
No one wants to go first. I think
Yeah,
there's a few agencies
yeah.
here, but Ben's like, all right.
Go ahead, state your name and tell us about it.
Sure. Thank you, Mr. Chairman. My name is Ben Moritz. I'm the Executive Director of the Community College Commission. We don't have extended concerns about it. There were some concerns about purchasing lists for marketing purposes. The colleges, as well as the university, routinely buy lists of graduating seniors so that they can send out information about come to school at Casper College or the University of Wyoming. This bill has been debated and discussed for quite some time. I do see that there is the exception where if the commission were to go to the governor in this case and ask for permission to do so and make a good point, that could be done. We had been concerned about the work that would take. I see it's now 2 years. And so that was the only thing that we had as a concern. It's largely been addressed. But I would have been remiss if I didn't come up here and speak to that based on some of the comments and concerns that particularly the admissions folks had at the community colleges. But this does seem workable in its current state.
And the 2 years you're referring to, I'm looking at this for 3 years. What's the 2 years that you're referring to that satisfied your complaint?
Mr. Chairman, I don't have it in front of me. Senator Rothfuss.
Bottom of
Oh,
page
bottom of
4,
page
line
4.
20.
Okay, so that was a change then, huh?
Mr.
Any other
Chairman, that-
questions for Mr. Wright?
Mr. Moritz, that was something we worked on through the interim, yeah, and it ended up changing a few times, trying to get it to the point where it worked.
Other questions for him? For Ben? Nope, nope. Thank you.
Thank you, Mr. Chairman.
It was Ben Wright, wasn't it? Nope. Huh? Go ahead.
Ben Moritz.
White?
Moritz.
Gee whiz.
It wasn't right.
I have a
either
little
way.
water in my ears. I can't hear. Mr. Morris, thank you. Morris, wow.
Moritz.
That was a way off.
There you go.
Let's see if I can massacre this guy.
This is the name, Moritz.
Oh, Moritz.
There you go. All right, good luck with yours.
Yeah, good luck.
Mr. Chairman, Jeff Kleins. I'm the Director of ETS, Enterprise Technology Services, the state CIO. Neutral on the bill, just wanted to identify myself and be here to answer questions that the committee may have.
Well, I think we should have some questions for you, Jeff. Yeah,
He's got information.
he's got information, yeah. Oh, questions for Jeff Klein? No, no? All right, thank you. Thank you for identifying yourself. You're kind of hard to miss. Any other agencies? Any other agencies? Oh, oh,
She picked you out.
Oh.
Ashley picked you out.
oh,
She
okay,
tricked us. Yeah,
We have.
it was a trick.
yeah.
Good afternoon, Senators. Angie Bruce, Director of Wyoming Game and Fish. And I actually wasn't going to testify on this bill because I was here for one later in your discussion. However, with the senator calling us out a little bit, I thought I might come up and just share a few thoughts. We have watched this bill over the last few years, and really there's not much impact for us because it currently aligns with all of our policies and procedures that we are currently doing. It may help give us clarity and support moving forward, especially with a lot of outside entities requesting information. I did check, and we do have a feature for any of our licensed buyers. When you go to buy a hunting or fishing license, you can opt in. So we can, if you opt in, check the box, then we will share when we are asked. We have not sold that data, though, for over a decade. So just providing that clarity and letting you know that this aligns with what we're currently doing. So with that, if you have any questions.
So Angie, you're saying that we do have to opt in, you don't automatically do it? Oh, okay, okay. Other questions for Angie? No,
Thank you.
no, thank you, Angie. Thank you for being here and clarifying that for us. Any other agencies? No other agencies? Public, how about a public comment? There must be lots of public comment out there.
She looks pretty public.
Don't get up again and then not, and then sit down. Don't do it again.
Come up here.
Come on up. Come on up.
Thank you, Mr. Chairman, members of the committee. I just want to make sure, because some people are putting entities that represent other entities at the last, so don't want to hop my turn. My name is Ashley Harpshoe. I'm the Executive Director for Wyoming Association of Municipalities. As a 501c6 private nonprofit association, WAM has been the foundation of support for all of Wyoming's 99 municipalities since its organization in 1928. WAM provides a vital educational and training resources that enhance the capabilities of all local officials, elected officials, and other municipal leaders. We promote policies that prioritize local decision-making, ensuring the voices of the 68% of the citizens who reside within these communities are heard and respected. We believe that the best government governs closest to the people, rooted in simplicity, accountability, transparency, and self-governance. Guided by these principles in our legislative agenda, we are committed to preserving the constitutional authority of local governments to serve effectively and independently. With that said, we absolutely support this bill, and we are happy to comply and eager to assist if this does become law. And we appreciate the guidance. So I'm here for assistance and any questions you may have.
All right, Ashley. Any questions for Ashley?
One more comment. I did have, my mayor of Pinedale was very excited about this bill, but there is a storm moving in, so he had to leave early. So he wanted to send his appreciation.
He wasn't that excited about a bill then, was he? Sorry. A little storm? What's the matter?
Pinedale's a long way.
Pinedale guy, he ought to be used to that. Thank you, Ashley. Anyone else? Anyone else like to speak to us about this?
Mr. Chairman, committee members, Eric Boley from the Wyoming Hospital Association. It's pretty rare that I get to sit before this committee. And Senator Rothfuss, thanks for talking about hunting licenses. It's got me all geared up for the fall.
You're ready.
Yeah. We're in support of this, but we've also submitted some potential amendments, which I would consider friendly amendments. And I think Senator Rothfuss did a great job of talking about our concerns with HIPAA in particular for all of our hospitals. And I think I'm speaking for most of the healthcare providers in our state. Our legal team took a look at this, and so I think Senator Nethercott may have forwarded on an email.
We've got it.
Yeah, unfortunately, it doesn't completely align, but I tried to make notes on there for which pages and where it would tie in. And I'd be happy to walk through those if that's okay.
Sure, Eric, you go ahead and walk through them.
Thank you. And so obviously,
Walk fast.
I'll walk as quick as I can. HIPAA is a 1,000-pound gorilla, and we want to be in compliance with that while we're in compliance with the state law. So our first suggested change would be on page 3, adding a new Romanet VII with just a definition of HIPAA. And then on page 4, in section A, 921-202A, after expressly provided or permitted. This is all legalese, so I'm just passing this along from our attorney. And then continuing on to section II, and this is for county memorial hospitals, and this would require approval of the Board of Trustees, which are appointed by the county commissioners. It would require the hospital board of trustees to go to the county commission, and that could be really challenging and erode the authority given to the county memorial hospital board trustees to run the hospital. And so we would suggest a short amendment in section II after the elected or appointed governing boards. And then
Is that on page 4 or page 5?
that's on, I believe that one's on page 4, if I'm tying it in right. Let me look real quick. Yeah, it's
4.
on page 4.
Yeah.
And then also inserting on, let's see, on line 17, the elected or appointed board or governing person. Hopefully that makes sense. You see where that ties in?
Yes, yes.
And then on page 5, Romanet III, this one changes a little bit, but the reason for this is the intent of these changes is to ensure that this is consistent with subsection A and to ensure that governmental entity hospitals can follow HIPAA when they purchase or sell practices or facilities and be assured they are in compliance with this section. And so the paragraph with the amendments would read, nothing in this subsection shall be construed to prohibit or limit the purchase, sale, trade, or transfer of personal data in the course of a purchase, sale, consolidation, merger, or transfer of a healthcare facility, medical practice, or health-related business, and I forgot my reading glasses, to or by a government entity or in a manner that is otherwise compliant with HIPAA or the Family Education Right and Privacy Act.
Yes, yes.
Thank you, Mr. Chairman. So on that, it's my understanding that under the condition of a sale or that type of a transfer, when your medical records are being transferred to a new entity, you have an obligation for written consent. And that's basically what HIPAA says.
Right.
So I guess I'm struggling to understand why we need any of this language, because HIPAA basically says comply with this act effectively. I mean, I literally just had this happen the other day. One of my doctors retired, so in the mail I get the form. You know, your medical records are going to vanish if you don't want to transfer them, and here are your options. And then I have to sign the little form. But one of the doctors in the practice is actually moved, and he technically had possession of it, so you know, if no action then. And again, that was a HIPAA required action. This bill is subservient to HIPAA, and I'm just saying this because I'm worried about creating new loopholes that don't exist without HIPAA. We defer to federal allowances, right? That's how we structured it during the interim. We basically say, if you've got authority under a federal law, you've got that authority. We don't conflict with it. We have an express provision on that. When we've talked about other exception language where people have requested, well, we can do this under the federal law, the more we write here, the more we create loopholes to this that don't necessarily have to be in the federal law. And that's my concern, if that makes sense to you. I don't want to create loopholes that don't need to be there because federal law doesn't demand them. What are your thoughts?
Mr.
Go
Chairman.
ahead, Eric.
Senator Rothfuss, I think it's, for us, it's the opposite. We want to make sure that we're complying with those law, but also ensure that we're compliant with HIPAA. And this is strictly from our legal folks. They just want to make sure that we have that surety to make sure that we're compliant. We're not fighting the law or trying to create
Yeah.
loopholes at all.
Yeah, Mr. Chairman, I understand, but I guess I'll just say this: when you bring a bunch of additional lawyers in, they like their language better. But I don't feel like what you're asking for is any different from what the law allows. But I don't know, because we haven't studied it for, we haven't done an entire interim. So either it does nothing or it does something bad in my mind.
Mr. Chairman, I'm just passing on.
Awesome,
I am
thanks.
not an
Yep,
attorney,
no
nor do
worries.
I claim to be one or want to
Don't
be
shoot
one.
the
Okay.
messenger, is that what you're saying?
Yeah,
Eric?
okay. No worries, Eric.
Yeah.
I appreciate it.
Hey,
And I would-
Eric, that one on page 5, that paragraph 3, I. Boy, that is one long sentence now with all that added in there, right? You don't have any punctuation. It's just one big sentence, isn't it?
Mr. Chairman, I am one long run-on sentence usually,
All right, all right,
but it's legalese, I guess. I'm not sure.
all right.
Just two more quick ones here. At least I hope they're quick. On page 7, under 921-203 in paragraph B, again, we're adding some language just to make sure that we're always in compliance with both laws. We would suggest an addition at the end of the paragraph to say governmental entities subject to HIPAA shall be deemed in compliance with this requirement if the governmental entity creates, collects, or maintains protected health information for any purpose permitted by HIPAA.
Okay, go ahead.
Then in section C, another slight change. I'm sorry, these things don't tie exactly together. But we would be adding, let's see, after retention period, we would then remove statutory and start with retention requirements provided by, or provided for in the two sections listed in any Wyoming law or regulation or HIPAA. And again, we're just trying to stay in compliance with HIPAA on those. And then the final one would be on, I believe it'd end up falling on page 8, adding a section D. Again, HIPAA includes a lot of the same requirements, but much more detail. The intent here is to ensure that government entities subject to HIPAA only have one set of requirements to deal with. And so we add that section D to basically codify that we follow HIPAA. And the language is provided. I won't try and read it for you because I still don't have my glasses.
D is your one sentence that covers 20 lines, right?
Yeah, it's a little short one, Mr. Chairman.
Yeah,
Mr. Chairman.
yes.
And on that, and I get your thoughts on it, Eric, because I don't think we talked about this during the interim when we were adding the HIPAA language. Fully exempting out HIPAA and basically saying if you're covered by HIPAA, you're not covered by this act, which is kind of what D does to some degree. There are a lot of loopholes to HIPAA and a lot of areas where HIPAA might not require as much data protection or as much overall data privacy as this act might, but not conflict. In other words, there might be some vacancies in HIPAA, and the idea here was not to simply say anything covered by HIPAA is exempt because all of those loopholes continue to exist, same thing with FERPA. It was more the idea that if we're in conflict with HIPAA, HIPAA wins, right? Which is kind of a different concept. And I feel like the D paragraph here, that last page, is more of the catch-all, well, we abide by HIPAA, so let's, we don't want to worry about the state very much. Is that what it's getting at, or am I missing the point there?
Mr. Chairman,
Yes.
Senator Rothfuss, again, I think it's the opposite. We want to ensure that we're always in compliance with it. But to us, it's the be-all, end-all. And I think there are a lot of securities and safety measures in there where even if we find that we're in breach of those, we have to self-report or we're fined heavily. And there are a lot of teeth in it. So I don't think it's to try to circumvent or surpass the state law. I think it's to just ensure that we're doing the very best for our patients.
Eric, on that page 8 change there, you've got that new paragraph D, and then it goes on with section 3, but you're not changing anything in section 3, are you?
Mr. Chairman, no, that's the last amendment that we would offer is that section D. They just made, it's just the entire bill copied differently in this format.
Okay.
And Mr. Chairman, I'd also say I really consider the previous amendment that Senator Rothfuss brought about our contracts to be very friendly. We use billing services where we share PHI and other things to make sure that we can bill and collect on, and with insurance companies, all kinds of things. So I think that's a great amendment.
Other questions for Eric? Other questions for Eric? You covered them all, Eric. Thank you very much.
Thank you, Mr. Chairman.
Thanks for being here.
Yep, thank you.
Anyone else from the public like to speak on Senate File 65? Senate File 65. Anyone else in the room like to speak on Senate File 65? We'll go to Zoom then on Senate File 65. Did you say we had a couple of people, Sue?
Mr. Chairman, we have 2, and they both should be coming in shortly.
Good afternoon, Mr. Chairman.
Good afternoon, it is.
Thank you for allowing me to join on Zoom. My name is Devin Brubaker, Executive Director of the Southwest Wyoming Regional Airport in Rock Springs, and also the President of the Wyoming Airports Coalition. We had some concerns about some of the language in this bill, but we are very thankful to Senator Rothfuss for bringing forward an amendment that does address those concerns. Airports are required to comply with multiple federal homeland security regulations when it comes to the transfer of data. And oftentimes we use, or we're actually required to use, a third-party service provider to transmit that data to the federal government. And so the amendment that Senator Rothfuss has brought forward to the committee today does address our concerns, and really appreciate his willingness to hear those. And we're neutral on the bill as an overall, but we do cherish people's privacy, and we look forward to implementing this by the deadlines at each of our airports. So happy to stand for any questions, Mr. Chairman.
Are your runways open today, or are you snowed in?
I'm actually in Denver, so I sure as heck hope they're open because I fly home tonight. We're good for now. We do have winter weather coming in. I'm supposed to drive your way tomorrow for a funeral. I'm hoping I can make it to Cheyenne tomorrow, so.
Yeah, well, I hope you can too, Devin. Any questions for Devin? Any questions for the airport manager from Rock Springs?
Yes.
Good job, Devin. Thank you.
Thank you.
And the next person?
Thank you, Mr. Chairman.
Yes, I can't hear you.
Oh, can you hear me now?
Yeah, I think
All
so.
right. Thank you,
There,
Mr.
there you go.
My name is Ruthie Bargo. I'm the Executive Director for TechNet Central Region. TechNet is the national bipartisan network of technology CEOs and senior executives. We promote the growth of the innovation economy, and our membership represents over 4.5 million employees, countless customers in the fields of IT, AI, e-commerce, transportation, cybersecurity, and more. We appreciate the deliberative process. We are here testifying in an informational capacity and to answer questions. The Select Committee has undergone a tremendous amount of discussion on this bill, which we participated in since this was a draft bill this summer and fall. And we would like to offer some friendly amendments that create the necessary balance to maintain public access to state and local government records, as well as the critical need for government transparency. The amendment that the sponsor discussed sounds like it could offer some resolution to those issues that we've been working through on this, and we look forward to reviewing that language and thank the sponsor for his work on this. We are testifying to encourage some improvements to simply avoid disruptions to government services, such as those that the Select Committee was told could potentially occur by government agencies during the interim discussions. We share those concerns because of our membership, and we are concerned that this could create obstacles to efficient and effective government administration, causing disruption to the provision of government services or the ability of state agencies to detect fraudulent government benefit claims. In its current form, the bill continues to prohibit the purchase of personal data by government agencies and no longer contains an explicit public records exemption. The sponsors wanted to keep this provision in place. We did voice our concerns, and there were also concerns from state agencies that government entities are often reliant on third-party data sources to provide essential government services to Wyoming citizens. The Select Committee heard testimony regarding the potential impacts about not being able to access this information from state agencies, including the Wyoming Department of Health in May and the Wyoming Department of Enterprise Technology Services in November. Government agencies reported that they depend on the private sector for data tools and services to support the delivery of services and benefits to individuals. We believe that there's a very simple solution here, and that the best way to address those unintended impacts would be to keep the existing language intact. Would be to provide for specific use case scenarios for government agencies that would not be affected by this bill. Providing these exemptions is a very similar approach to the 22 consumer data privacy bills that have been passed into law. This is a widely adopted solution. We would like to review that in context of the amendment that the sponsor is offering as well. Thank you for your time today. We look forward to working with the sponsor and the committee.
Good, thank you. Thank you, Ruby. Any questions for Ruby?
Ruthie.
Ruthie?
Ruthie.
Oh, really? All right, any questions for Ruthie then? Should have looked at my list.
Mr. Chairman.
Yes, a question for Ruthie.
Not necessarily a question. I'll start off by saying hi, Ruthie, and then I'll say, make sure you get a copy of this amendment, which I think addresses a lot of the concerns that we've discussed since we last met. Thank you.
Other questions for Ruthie? No? All right, thank you, Ruthie. Thank you for being here with us. That's all of them on the Zoom. We've heard the room, we've heard the Zoom. We'll close public comment and Mr. Chairman, or
Move the bill.
would you like to move the bill?
Move the bill. Second.
Would you like to second it? Yeah, seconded by Cooper. Sue? All right. Do we have any changes or do we just go ahead with the bill like it is?
Maybe you change it.
Mr. Chairman?
Yes, 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 yes. Senator Cooper, go ahead.
No, I defer to Senator Rothfuss.
Senator Rothfuss, go ahead.
Thank you, Mr. Chairman. I'd move the amendment that I brought, which provides for an allowance for contracted services for transfer of personal data. And we've all got a copy of that here.
I'll second that.
Moved and seconded. Senator Rothfuss, and you already told us about this one,
Yeah,
so we shouldn't have too many more questions.
if you'd like me to reiterate, I certainly can, but
No, I think you did a fine job the first time.
You
Gotcha.
rated already.
I
Yeah,
felt
yeah.
like it.
Yeah, he already told us all about it. Yeah. Any other questions on it, though? No other questions? We got a question.
Mr. Chairman, just for purposes of discussion within the committee, one of the big debates that we had from the select committee was whether or not we were weakening state, local governments, including law enforcement related entities, and subordinating any power, for lack of a better term, to private companies who actually have all the data. And so you're putting government in a much weakened position, which I know is typically what we think is best, unless you're talking about big data, who controls everything. And so the only kind of bargaining or balancing of powers between big data that knows more about you than you do is potentially government intervention and government information. And so there is, this seems like a good idea on its face to limit the government's use, access of data. But just recognize that if the government isn't able to, big data already has it and is. And so the ability to kind of to play in that space or to regulate that space, and to understand how that space is used is limited. And so I had great hesitations actually about the bill, still do, for those reasons. And so it's kind of the opposite of how we typically are in Wyoming. In this case, big government may be necessary in response to the power of big data.
Are you still on the amendment?
Yep, I'm on it all.
Okay, all right. All right. Anything else on the amendment? Anything else on the amendment? All in favor of this first amendment to Senate File 65, signify by saying aye.
Aye.
All opposed, same sign.
No,
And the amendment sneaks by, the standing committee amendment sneaks by. Is there another amendment that anyone wants to bring forth? I see there's one from Dave Pickard.
Mr. Chairman, I chatted with Mr. Pickard. He gave this to us for the last time and said that he doesn't have that concern any longer, and particularly with the new language, so
Oh,
I don't
okay.
think he's here.
I didn't see him out there, that's why I was
Yeah.
wondering.
So
Usually he would be
He
here.
mentioned to me not to worry about it at this point.
Okay, okay, all right. Any other ones to come before?
And Mr. Chairman, on the proposal from the Hospital Association, this is a lot of language change, and it looks like it was a very thorough review of it, but, I'd like to go back and work with Mr. Boley after the meeting, honestly, and try and figure out if we can synthesize these changes into perhaps a more modest change that addresses those concerns and makes it clear that if HIPAA provides an allowance, that allowance will be honored. And maybe we can do that with just one change to one paragraph instead of right around 11 changes. I think it would keep the bill cleaner. We had that, that intent is obviously the purpose of that Romanet 3 on page 5 was to have a nice, clean, here's your carve out HIPAA. If you're following HIPAA, you're going to be okay. So that would be my request, is I'll take some time and work with the Hospital Association to come up with an amendment to that Romanet 3 there that more appropriately captures the interests of the Hospital Association, rather than stepping outside of it.
So we need to put the bill off? for
No,
you to
Mr.
do
Chairman,
that, Or you,
no, we can just do it for committee of the whole instead of standing committee.
So
Unless somebody's particularly concerned about
don't
it.
do
but that would be my
anything
request.
with Eric's information? We'll
At-
do it in
At this
committee of the whole?
point, that's what I would say. Yeah.
Okay, all
That
right.
would be my ask. If others feel inclined to do otherwise, then we can chat.
Yes.
Mr. Chairman, thanks. So just a question too for the good senator. I want to bring this to your attention before we just carte blanche pass this out. So if this bill applies to law enforcement as well? No?
Exempted.
Where?
Right off the
Madam
bat.
Chairman, recall we exempt law enforcement and the judicial branch. And 1 second while I
I did this already. Thank
While I
you.
pointed to, yes, you did this already. Yeah, you're just forgetting the 8 months ago when you last made the point you're about to make.
I'm all good.
Anything else on proposed amendments? There's a letter here, but I don't believe it's any proposed amendments. Well, maybe it is. Is this Zachary Taylor? Is that a proposed amendment or not?
Mr. Chairman, there were some concepts in there.
Yeah.
I read through this. And I do think that a lot of the concerns that are there are actually included in the amendment that we passed, and then other aspects of it are, not necessarily consistent with the interest of the bill. So I didn't see anything there that we needed to take action on at this time. But if any of the members, see anything that Mr. Taylor raises through his letter.
All right,
we can
Mr.
chat about it.
Zachary Taylor, we are not taking any action on your letter. If that doesn't suit you, let us know and we'll work that on the cow also. Thank you. Any other amendments to come before Senate File 65? Hearing none, sensing the body is ready to vote on Senate File 65, I think I'll do roll call. Roll call, Sue,
Mr.
on Senate
Chairman,
File 65.
Mr. Chairman, this is a roll call vote for Senate File 65. Senator Cooper.
Aye.
Senator Jones. Senator Nethercott.
Aye.
Senator Rothfuss. Chairman Anderson.
Aye.
Mr. Chairman, you have 5 ayes.
That's snuck by, and I'm thinking that we should have Senator Cooper do this on the floor.
agree.
Support that.
Can we get a roll call on that?
Well, there, we just killed that bill.
No, I think we'll assign it to Senator Rothfuss. I think he's got the information on this bill to do this. So Senate File 65.
Did you get that deer in the headlight deal?
Yeah, I did. Senate File 65 will go to the floor with Senator Rothfuss presenting it. Next up is Senate File 83. What time are we back into? Senate File 83, and I believe that we have a senator here to bring us forward on this bill. Senator Steinmetz, please.
Thank you, Mr. Chairman and committee. Today I bring to you Senate File 83, Large Energy Project Funding Legislative Approval. And if you remember, fellow senators, since all of us were here last year, we had a big debate on the floor about how energy policy was being crafted and about the energy matching funds within the state budget and how that was being administered. And it's a policy decision for this committee and for the body in the fact that I'm trying to reinsert legislative approval when we have these large energy project fundings. So if you go into the bill, you'll see we have a definition of what an energy project is. It basically covers everything we've been doing here in the state of Wyoming. There are no exclusions on that at all. It defines on page 3 what a large energy project means. That's anything over $400,000. Defines state funds. And then at the bottom of page 3 and going on into 4, that just requires the report of who would be receiving the funds, the amount of the funds, whether matching funds are available, and the amount of state funds awarded. And none of these funds can be expended without further legislative approval. Right now, it has that going before the Appropriations Committee. You might want to change that to this committee. That is on page 3, line 21. You may want to put both. And then on page 5, for the purposes of this subsection, legislative authorization shall be through enactment of a bill. The reason for this is just like many of you have served on TRW or Select Water, and we have those large project bills. We have the omnibus water bill every year. We have the large project funding bills every year. And that's what this seeks to set up, is a process for our energy projects and do the same thing rather than just allow a fund, an energy fund for one person or an agency to put forth. On the bottom of page 5, 9, 12, 104, that pertains to the Wyoming Business Council because some of those funds are running through them. And then on page 6, the energy, it pertains to the Wyoming Energy Authority. And so with that, Mr. Chairman, being sensitive to your bill schedule and your time, I would be happy to answer any questions. I do have a proposed amendment just to take care of that it does not apply to impact assistance, and that was something that was asked for by industry. If I could pass that out to you. And so just to make that very clear that it doesn't apply to any impact assistance. And so it's a policy decision about how we conduct our business. I believe that the legislature should be more involved in appropriating such a substantial amount of funds in the state and setting energy policy. So with that, I'd stand for any questions on the bill.
Questions for Senator Steinmetz? Questions?
Thank you.
Senator
Mr. Chairman.
Cooper.
Senator Steinmetz, where did you derive that $400,000 number from? Could you elaborate on that just a little bit for me? Thank you.
Mr. Chairman, Senator Cooper, thank you for the question. We kind of tried to match it on how, we've been increasing how much can be expended in the other funds with large projects and with Select Water, how much money can be expended before legislative authorization.
Well, is that new language? That's not new language, is it? That 400,000?
Mr. Chairman, this whole bill is new language.
Oh,
That's just kind of paralleling. I mean, I'm open to you moving that number if you see fit because you deal with these projects more than I do. But as far as our other projects, that's kind of the standard.
Yes, Senator.
Thank you, Mr. Chairman. Senator Steinmetz, so the 400,000 is what we have for a large water project, is that accurate?
So yes, Senator Rothfuss, Mr. Chairman, Senator Rothfuss, I think we moved it up and Senator Cooper might remember, that's what it's required before you have legislative approval. That's how much spending authority that they have on their own.
And Mr. Chairman, is this bill, it looks like it is, but is this bill then modeled after the statutory provisions for like Select Water and water project approval, and then same thing for Natural Resource Trust
Yes,
Fund approval?
yes, correct. Thank you, Mr. Chairman, through you and Senator Rothfuss, that's correct.
Thanks.
So as I understand it, you're saying that this would bring the project back to the legislature before it goes forward, as opposed to going through the governor's office. Is that correct?
Mr. Chairman, that's correct, because as you know, there's been around $450 million. Maybe you cut 100 million out last year. I can't remember how that ended up, but it's been a substantial amount of money that was put there and then just appropriated through our one appropriation in the budget. And so for me, I believe it's more transparent for the public to understand what's happening, to provide comment on what's happening regarding energy projects in the state of Wyoming, and for the legislature to weigh in on that as the representatives of the public as well. And so that's the impetus of this bill.
Thank you. Senator,
Mr. Chairman, Senator Steinmetz, is there any provision in here or some change that we could make if a project comes up and time is of the essence, and if we are a long way away from having session again, that there's some way that we could still get the energy project through?
Mr. Chairman, Senator Jones, that would be something for the committee to contemplate. We have, if that happens as far as select water, we have energy emergency funds available that we set up a few years ago because we were having failing infrastructure. So it's possible that a provision like that could be put in with a cap on how much could be spent.
other questions? Other questions? Hearing none,
All
thank
right,
you.
thank
Senator
you.
Steinmetz.
Thank you, Mr. Chairman.
Agencies that would like to speak on this bill?
Good afternoon, Mr. Chairman. Members of the committee, my name is Rob Krieger. I serve as the Executive Director of the Wyoming Energy Authority. I know you have a couple more bills on the agenda and we're running short on time, so just want to address a couple of the questions. If you want me to walk through our process on the energy matching funds now, I'm happy to do that. I will say in the current language that you all passed in the budget last year and previous years for the matching funds, we have to notify Management Council, not we, the Governor's Office has to notify Management Council and JAC before we expend any funds out of that account. That does not require approval though, it's just a notification. To the amount of funding, over the years, as you all know, you started the matching funds a few years back. The total in the energy matching funds is 155. That's the total appropriation, 155 million that you all have done. And then an additional 100 million for a separate account for large energy funds. So just want to make sure we clear that up. So a total of 255. The question about public comment, as you all know, we administer the energy matching funds. Nowhere in the footnote in the budget bill does it require public comment. We have went ahead and did that anyway though. So when we recommend a project to the governor, once we have decided that as our review committee, we open up a 10-day public comment period that allows folks to email our office, and I provide those to the governor's office before he makes his decision on those projects. To the timeline discussion, I'm happy to work with the bringer of the bill on this too. I think that's worth looking into. The reason being is some of these projects do leverage Department of Energy funds. Sometimes if they get the award from DOE, they have 2 months, 3 months, 4 months to figure out how that negotiation works before DOE pulls back that award. So I would keep that in mind as you all look at this bill moving forward. Other than that, Mr. Chairman, I will point out there's a discrepancy. If we look at last year's budget, when you all set aside the large energy matching funds, you define large energy projects as over 50 million. Obviously, this is a little different than that. So for us that administers those programs, maybe truing those up or figuring out what that amount is would help us as we look for large energy projects. But other than that, Mr. Chairman, again, understanding the time constraints you're under, I think hopefully that clears up some things.
No, don't worry about the time constraints. We've got all kinds of time, Rob. Yes, Senator Rothfuss.
Thanks, Mr. Chairman. Yeah, I think we need to take some time on this and talk about it. And if we have to lay back those other bills, that's okay. Mr. Krieger, a couple of questions. The first gets to the timeline, which is honestly my biggest concern. With the water projects, we plan those 5 years ahead, and there's like a long, slow process, and then we do have emergency funds available. In receiving all of the updates from the projects that have moved forward through this, most, if not all of them, seem like they come together pretty quickly. Like and they tend to be reliant on Department of Energy funds or some other external fund availability. So we might talk about the project for a little bit, but then it hits, and then the funds need to be available to move it forward. Is that accurate? Am I reading that right?
Yeah, Mr. Chairman, Senator Rothfuss, I think you are. I think just to backtrack, when you all first set up this fund, That was shortly after a couple bills had passed in Washington DC that opened up possible energy projects. And the whole idea around matching funds was exactly that. Some of these DOE programs require a 50-50 match, an 80-20, you name it, they're all different. And so the idea was to be able to make sure the companies that want to do those projects here in the state of Wyoming, if they need help on that match to make sure we secure that project here in the state and not somewhere like Texas or North Dakota, that we can evaluate that and provide part of that match. So yes, you're right, it varies from DOE programs. I would point out in the large energy matching funds and the original matching funds footnotes, it says federal or private. So we've had projects where it's just us with the private company, us with the feds and the private company, so it can be a mixture of the three.
Mr. Chairman, follow up?
Yes.
And so we've had 255 million or have 255 million total appropriated at this point in time. Of that, how much is spent or encumbered?
Mr. Chairman, Senator Rothfuss, the 100 million from the large energy matching fund is fully there. We haven't spent anything out of that. We are currently in the middle of a review, so we have of the original 155 million appropriation, we're at 46.3 left.
Mr. Chairman.
Mr. Chairman, if I could, I would point out that we have 10 projects in front of us right now that we'll vote on. We as the review committee in February, and the total of those projects is 47. So we're in the hole by about 1 million right now.
What was the figure on that other one? You said there was, of the 155, there was something that was already,
Yeah, Mr. Chairman, we have about 46.3 million remaining in that.
and then you're voting on 50? Really?
Mr. Chairman, there's 10 projects in front of us that amount to 47 million.
And Mr. Chairman, then, so you're about 109-ish million spent out of the 155. What's the total match on that? So we spent 109. What has private or federal spent?
Mr. Chairman, Senator Rothfuss, not to make this more complicated, the original energy matching fund did have 18 million in earmarks, so I do want to shave that off the top first.
Okay.
So out of the roughly 96 million that we've spent through the energy matching fund program, we've leveraged over 260 million on top of that via private or federal funding.
So, Mr. Chairman, 96 million has brought in an additional 260. Is that accurate?
Mr. Chairman, just in capital investment, that doesn't count jobs, severance tax,
Right.
and all that. Yep.
Capital, thank you. And, Mr. Chairman, then, let's say this bill were in place when we started. What would have happened? Of those projects, how many of them would have been challenging to manage as a result of having this timeline where you would go through your approval process, it would then go to the legislature, and as a committee, the committee would prepare legislation that may or may not approve it, that would then come to the legislature, we may or may not approve it. So basically contrast how it went versus how you would envision it going under this for the same scenario you worked with.
Mr. Chairman, Senator Rothfuss, it's a good question. I'd point out the 16 projects that we've done, only one of which is under 400,000. As to your question around the timelines and how if this bill were in place, when we have companies apply to us, they do a concept paper first. And in that concept paper, there's many things, one of which is obviously what the project is, if they have their match, showing us they have their match. But one is also, when do you need that match, right? So if there's a company that says, hey, we found something, but we want to secure this money and do the project 5 years from now, we usually kick that because, again, we're here to try to get these projects done that are ready. So it's kind of hard to say how many would have kind of run up against a potential timeline of you all being back. That's, again, where if you decide to move this forward, I'd like to work with you all or the bringer of the bill to figure out if it's an emergency fund, like was mentioned, or something, if we have timelines like that, that we can address that so we don't miss these projects.
Yes, go ahead.
Do you usually approve from the state the match pending federal match first? Or do you approve from the state after the federal has been granted, assuming match? I hope that made sense.
Mr. Chairman, yes, it did make sense. This was a tough decision when we first started on how to implement this because there wasn't clear whether or not we should wait. We took the position as you have to have your match ready the day you come to us. So you have to have a letter of award from DOE, or if you're a private company, you have to show us you have that money. And the reason we did that is we didn't want companies to be able to come to us and say, hey, you give us 10 million, then we'll go raise the other 10 and we have a project, right? We wanted to be last in, basically, on it, follow on capital for the project.
And
Yes.
do you think that's held back any projects, or has that worked well?
Mr. Chairman, Senator Rothfuss, we actually have a project in front of us right now that came to us originally back this last summer, summer ago, July, and said, you know, they wanted some matching for a project. They were going through DOE. They didn't have approval from DOE, so we kicked them, and now they're back. They got their DOE approval, so we're reviewing them in February. And again, the review committee will take their assessment, but it hasn't hindered that. They have time to get that award still.
Okay, Mr. Chairman, on that point, my concern, and the reason I'm asking these questions, is this process, if you apply for DOE funding that needs a matching share, and we have a process where we're waiting for the grant to be awarded, and then we started the process of, all right, well, let's see if we can get it through the legislature, that's going to add a year to a year and a half after a DOE award takes place. Could they wait that long after getting a DOE award? I can't imagine DOE is going to say, all right, we're willing to wait for you to achieve your match. I would expect that award would fall through.
Mr. Chairman, Senator Rothfuss, I can't speak for DOE, but my guess is yes, they would probably not wait that long.
One of the things we set that up with the energy group was that you'd be nimble and ready to do these projects, because we sensed that there would be times that time would be of essence. And that's why we didn't set it up for the legislature to approve it. And legislature approving it might be okay if we're in session, might not even be okay then. And that's one of the problems that we saw in the beginning, that we wanted that you could do 16 projects and move right through and get that done. Incredible that you brought in 260 million with the money that you put into that. That's wonderful. Well done. Any other questions for
Mr. Chairman,
Rob?
just briefly, and just for the people who might be interested, can you briefly describe or give some information on the 16 projects so far, if that's available?
And Mr. Chairman, Senator Nethercott, not to do a shameless plug, but our new annual report has this in there. We tallied it up on percentages. 85% of the projects we've done thus far have gone to fossil fuel projects, 10% to nuclear, and 5% to renewable. So that's the makeup. I do want to just backtracking a little bit to, I want folks to understand that process as well. The governor doesn't see those projects until we have that recommendation to him. I know these funds are technically in his office, but we have the School of Energy Resources, the Business Council, Workforce Services, EORI, you name the energy entity, do those reviews with us, and then we decide. Sometimes we'll reduce the ask or deny it. We've done that plenty of times too. But then at that point, that recommendation is what I bring to the governor and explain. And then at that point as well, the Attorney General has to do a review to make sure it's constitutional as well. And so that's kind of that process.
Are there projects that the public would be familiar with if you named them?
Mr. Chairman, Senator Nethercott, yeah, our first two projects, one of which was Frontier Carbon Solutions. That was a sequestration hub in Sweetwater County. We spent just under 10 million on that one. They leveraged, they brought in federal and private investment of over 50 million. On top of that, that was for 3 Class 6 wells, 1 monitoring well, and the other was the BWXT microreactor project. It has gotten quite a bit of actually global news on what we're doing there. That's with a company that has been around forever. They've made micro reactors for Navy subs since the 60s. We reached out to them to figure out, hey, how can we bring these on land and see if that would work for some of these folks that are wanting behind the meter or self-generation. And that project's going very well. So those were the first two. We have other ones, a coal to hydrogen project with Black Hills. We have a enhanced oil recovery project with Principal Petroleum. Some with Jonah Energy, Blue Spruce Operating is a helium project. There's a handful.
Other questions? Other questions for Rob? Hearing none, thank you, Rob.
Thank you, Mr. Chairman.
Very good information, well done. Well done. We're glad you're moving that quickly. Thank you. Any other public comment? Any other public comment?
Thank you, Mr. Chairman, members of the committee. I'm Natalia Macker, President of the Wyoming County Commissioners Association, and just wanting to provide brief comments along the lines of the discussion you have already had, that our energy producing counties are concerned about the potential delay on the front end of projects. And so at this point, our association is opposing this bill based on the timelines, and appreciate the discussion you've had thus far. Thank you.
Questions for Natalie? Natalia? Oh.
Thanks, Natalia.
Thank you. Any other public comment? Any other public comment? And no Zoom comment? No room comment? With that, we'll close public comment. Committee, what's your pleasure? Committee, what's your pleasure? I don't think we're going to move the bill, Sue. No action on that bill or the amendment. We'll close that one out. Thank you. We're not going to move on to those other bills. We don't have time. It's almost time for the session to start. So we'll move Senate File 97, Trust Code Revisions, and Senate File 134 to Monday. All right, good. Anything else to come before the committee? No? All right, committee is adjourned. Thank you.